Assalamualaikum. My name is Nurajat Niti Baharudin, 051748, and here together with me is my friend.
My name is Nurul Atra binti Hamid with matrix number 051658.
And we are going to present our project paper with the titles of Stateless Children in Malaysia and Analysis Study on the Causes, Effects and Solutions. On today's presentation, we are going to mention about introduction, the problem statement, objective, methodology and finding, and the conclusion of our project paper. And now I will pass this presentation to my friend.
For the introduction of our topic, stateless children are known by several names by given the public, which are undocumented children, invisible children, or hidden children. The stateless people are fighting for their rights of basic human beings, as they are not treated as a person where all of their rights are deprived due to the non-citizenship. The person who is considered as stateless is a person who is born, bred and raised in Malaysia and not entirely foreigners, illegal migrants or refugees. They are genuinely entitled to the citizenship of Malaysia but are denied the nationality because of certain problems which are not according to the compliance of the constitution. For the problem statement, there are few problems of statelessness that happen in Malaysia, which are Indian groups, the refugees of Rohingya, the stateless people of Sabah or descendant of Filipino or Indonesian migrants, and illegitimate children. Rejection of citizenship by the National Registration Department has happened in decades where the applicants comply to prove their relation to Malaysia. Most numbers of stateless people conceive of innocent children that were born in Malaysia but were denied citizenship because of non-compliance to their interpretation of the law. The child of a wedlock can obtain citizenship if only mother has citizenship of Malaysia. The federal constitution states that a child can be considered as Malaysian if one of the parents is a citizen of Malaysia that is recognized by law.
Moving on to the research objective of our project proposal paper, which is to examine the cause of stateless children that rapidly happening in Malaysia, to analyze the effect of stateless children in the future, and to identify the best measures that can be taken by the government to combat the issue of stateless children in Malaysia. Moving on to the methodology, we are using the doctrinal research of qualitative method, which use two data, which is primary data, which consists of statutory provision and citizenship cases related to stateless children, and the secondary data, which are reading literature in the form of article journals and books and online, dividing reference into issues, conclusion, findings, and methodology. We have divided our findings into 4 chapters, which are the second chapter is factors of stateless children in Malaysia. The third chapter would be the consequence of the stateless children's right. The fourth chapter is the analysis of legal framework, and the fifth chapter is solution of the issue to the stateless children.
So moving on to chapter 2, factor of stateless children in Malaysia. There are a few main factors that contribute to the cause of stateless children in Malaysia, in which failure of marriage registration and birth of the children, foster children, immigrant children, neglected children, and illegal immigrant. Okay, so first of all is adopted children. And then the second one is unregistered birth. And then the third one is failure of marriage registration. And then the fourth one is children of refugees and undocumented migrants. And then lastly is abandoned children. Okay, so moving on to chapter 3, which is the consequence to the stateless children's right, where we touch on the denial of human rights, and then the absence of nationality, and lastly is difficulty to access to education. On to the chapter 4, which is analysis of legal framework. We focus on the Malaysia legal framework. First of all, statutory provision, which is federal constitution. It stated that in Article 12, Clause 1 of the Federal Constitution provides that no prejudice as referring to Article 8 of Federal Constitution against any individual merely because of the different descent, colour, place of birth or religion based on the registration at the administration upon an institution of education administered by the government and the recruitment of students or the fee payment or financial support from the government authority for the management or learning of students in any academic institution. For the first case, Lim Juan Sien and Pengarah Pendaftaran Negara, which is in this case, it is about the issue of where the father is a Malaysian and the mother is a Thai nationality, in which resulted to a child wedlock. However, the child follows the nationality of the mother and not considered as a stateless. For the second case is Om Bung Hua alias Chimpan and another and Menteri Hal Ehwal Dalam Negeri and Malaysia, where in this case the judge decided that the application had the appellant had the duty to show his birth certificate in order to identify himself as a Malaysian citizen. So for the third case is Lee Chin Pon and another and Registrar General of Birth and Death, where the issue of adopted kid was born in Malaysia and adopted by the Malaysian parents, and the court granted Malaysian citizenship to the child, referring to Article 14(1)(b) of the Federal Constitution. Is the case Pang Wisi and Pendaftar Besar Kelahiran dan Kematian Malaysia, where the judge referred to the Adoption Act 1952 and Article 14(b) of the second schedule of Federal Constitution, where the applicant failed to prove the biological criteria that to prove the citizenship of Malaysia.
Moving on to Chapter 5, which is the solution to the issue of stateless children, there are three solutions that can be taken, which are judicial review of federal constitution clause in regards to citizenship. The second one would be having specific procedure for the stateless child to be recognized. And the third one would be adapting international human rights law in our judicial interpretation. In regards to the first solution which can be taken by the government, the procedure of acquiring Malaysian citizenship under this article appears to be uncertain as the phrase of there is even no fixed time frame for the application of the citizenship to be resolved, and the consequence is that the fate of the children concerned hangs in the balance pending the whole application process and the court proceeding that may ensue afterwards. Second solution would be having specific procedure for the stateless child to be recognized. Many states do not have specific recognition procedures for the stateless person. The issue will indeed arise during the refugee status determination procedures, and the stateless person may then be proceeded within that framework, which includes humanitarian or subsidiary protection. The person who shall decide if a person is a stateless is a qualified personnel who are specialized in the field of statelessness and who can impartially, objectively examine the application and evidence supporting it. Moving on to the third solution, which is adapting international human rights law in our judicial interpretation, it has been mentioned and provided accordingly in Article 15 of UDHR that every single person has a right to nationality and no one shall be deprived from such nationality. Malaysia has been taking a liberal approach in interpreting the stateless issue by backing up such idea with the significance and the position of international law in many cases that affects the judicial manner in the country. It is highly recommended that Malaysia will allow endorsing the national law to the 1954 Convention in relation to the stateless person and the 1961 Convention on the Reduction of Statelessness and ICCPR. Moving on to the conclusion, it can be concluded from the study above that there are numerous ways to handle the issue of stateless children in Malaysia, and the challenge of the child's statelessness requires consciousness, commitment, and effort from every hook and crook of the state, be it the government or the people. As fundamental as birth registration, it does not help to curb the problem and protect groups of children that have suffered for the time being. Therefore, through the government action and willingness of the country to review the framework and start to take into consideration the implementation of the international legal framework might be needed to solve the stateless issue in Malaysia. Malaysia should be able to open their eyes and look far beyond the neighboring countries on how they resolve the humanitarian issue that has been haunting the country. The issue of statelessness is not a small matter and shall be looked into as the sufferings that cannot be seen now can cause the trouble in the future. That's all from us. Thank you.